Good afternoon, everyone, and welcome to our bi-weekly community conference call from the law offices of Rajiv S. Khanna, immigration.com. I am Rajiv. Uh, you must have heard the disclaimers when you logged in. Subject to those disclaimers, we are going to answer your questions as best as we can. I'm going to go through the frequently asked questions first, and I remind you that our next call will be in 2 weeks. Every other Thursday, we hold a call. Very few exceptions, and we've been doing it for many years. So, first question is Mira99, and I have marked this as a frequently asked question. She had asked me earlier, last conference call, she said, converting from H1B to H4 and back again. I'm on H1B, lost my job, I-140 is approved. I want to move on H4 visa so I can stay in USA. My wife has an H1B. How many days can I stay in USA as I lost my job on my H1B visa? So we were talking about that the last time, and I was telling him that you've got a 60-day grace period or the time remaining on your I-94, whichever is shorter. So when you lose a job, you have 60 days or the time remaining on your I-94, whichever is shorter. And when the H4 is filed within that time period, you can stay in USA. But if you want to convert back to H1, there are two possibilities. Either your H4 is already approved or it is still pending. If it is already approved, government will be able to give you an H1 again within the same, without you having to go outside USA, within the country. Okay. So if on the date your H1 is decided, your H4 is no longer pending, but it's already approved, good. You can get your H1 within USA. But if it's still pending or already denied, then you have to go outside USA for visa stamping. So all of this is possible, but there are certain restrictions, so be careful with all these moving parts. And you know that H4 cannot be premiumed. Previously, and I don't know, they have some inexplicable reasons why they would decouple H1 and H4 premium processing, but they won't do H4 premium processing, okay? So this was the previous discussion. Now let me see what the new questions are. So the first question following this discussion is, 2-month grace period on H1B searching job can be taken for one time in whole life, or it can be taken multiple times. And the answer is that it's not 2 months. 2 months can be more than 60 days, right? So it's 60 days. 60-day grace period can be taken multiple times. It is applicable to each application, whether it is a new H1B, extension, amendment, repeated amendment, different employer, transfer. So you have a 60-day grace period multiple times. It's not just one time. When the regulations were first announced, they were planning to make it only one time, but then they backed off and they made it unlimited number of times. Question number 2. If one H1B's extension is filed and receipt number received, and after 1.5 months still first extension is pending, and there's another extension filed with another employer, is that any problem? This is fairly safe. So I think further down somebody has asked me the same question, and I'll clarify this for you right now. And this is a little complicated to remember and understand, but I'll do my best to explain. First of all, there is no limit to the number of transfers, extensions, amendments that you can file simultaneously. And the approval of one does not necessarily overrule the approval of another. So let's say I'm working for employer X. They filed for an extension. Employer Y filed for a transfer and extension. Employer Z also applied for a transfer and extension. You can take any of these that you want. So if X gets approved, then Y gets approved. You can choose to stay with X if you want. From immigration law perspective, if you've signed contracts and all, that's a different issue. But from immigration law perspective, you could choose to stay with X even though Y is approved. Then Z gets approved. You can work with X, Y, Z, whichever you want. but not all three together, successively. I hope that makes things a little clearer. Okay. So under the law, it does not matter if you have multiple cases pending at the same time. This is not only safe, it is often done. We do it all the time. This is nothing new. Okay. So keep this in mind. You are good with that. Then after posting these questions, there was another post. Question number 3 was, if I move to H4 visa for some time and H4 visa application is pending for approval, after 15-20 days I get a job, what happens to the transfer, etc. And exactly I told you in the beginning, the only problem is you may have to step outside USA for visa stamping if your H4 is not already approved when they adjudicate your H1. I hope this helps. Now, if anybody has any follow-up questions, press *5 on your phone. Any follow-up questions on this, press *5. Okay, let's see. I have one question from Louisiana. Okay. Louisiana, go ahead. We can hear you.
Yeah. Thank you, sir, for helping us. So my question is, USCIS will tell us that let's say my H4 is like pending. We just filed, and after it's pending for a month, and then I get another job, and that company will file my H1B transfer in the premium process. So it's like I'm not going out from US. So before I join new employer, USCIS will tell me that I have to go out and do the stamping, or I have to myself go
hang on.
out and do the stamping.
They will tell you. Because they will say, well, your previous H1 expired 3 days ago, your H4 is pending. So when you filed this H1 transfer, you no longer were on H1 status. You were in authorized period of stay because of a timely filed pending H4, but that does not give you full status. You cannot convert from pending H4 to H1. You can only convert from approved H4 to H1. Therefore, you have to go outside US.
Okay, and do you know how much time H4 approval is taking? Just tentative idea.
Well, I think I mentioned it last time also, that we were going to file a lawsuit against a pending H4. This H4 was filed in August 2018 along with the EAD, and it's 1 year later, it's still pending. So we just filed a lawsuit on last Thursday against the government in Washington, D.C. That, 13-14 months delay in H4 and H4 EAD is nonsense. So that's what that should tell you. Go ahead.
Is that much delay happening with all the states?
Well, I can tell you this, that hundreds of lawsuits have been filed against H4 EAD delays. Okay.
So last question, let's say H4 is filed and it's go for 1 year pending. So I can stay in US, right?
Oh yes, absolutely. As long as your H4 is timely filed, you can stay in the USA awaiting the outcome of the application, no problem.
Because H1B, I think 270 days is a period.
No, not at all. That's not how it works.
Okay,
it's 240 days to continue working in an extension without change. But if it is an extension with change, you can work for unlimited amount of time as long as it is pending. Or if it is it's a transfer or amendment, etc., you can work as long as it's pending. Also remember that even after 240 days in an extension without change, you would have to stop working, but you can still continue to stay in the USA as long as the case is pending. Okay?
Okay, thank you, sir.
You're welcome. Good luck. Okay, let me go on to is there another question? Let me just make sure. Oh, there is another question. 1 second. This is from Pennsylvania. I remind you folks, I'm not taking new questions, just follow-ups on what I discussed. Pennsylvania, go ahead, please. Pennsylvania.
Good afternoon, Rajiv. This is a follow-up.
So say like a H4 and H4 EAD is timely filed,
Mhm.
and it's still pending like say like 4 or 5 months,
Mhm.
and then is it the H4 EAD we can continue to work even
No,
our
no, no,
H4
no,
the current
no,
or
no,
this EAD
no, 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 no,
expired?
no, no, no. You cannot. You cannot.
So we need
So,
to wait until the new H4 EAD comes.
absolutely. And this is true also
All right.
for
Okay.
H4 EAD extensions. There are some kinds of EADs. So now there are 3 or 4 different kinds of EADs: OPT, STEM extension OPT, CPT, I-485 based EADs, and H4 EAD. All of them have different rules. So for H4 EAD, you cannot work. Even if you file an extension, you have to stop working until the extension comes. Okay?
All right. Okay. Thank you, Rajiv.
You're welcome. Good luck, sir. Okay, so let's go on to the next frequently asked question. I think we have about 3 of them today. Here's another one from Unicorn77. I'm a software engineer, plan to marry a green card holder in Texas. We want to stay together. My I-130 can be filed in the same month if it has to be filed post-marriage. Well, first of all, in order to file the I-130, you have to be married. You can file it the same day when you get married. There is no limit on how long you have to wait. In other words, there is no cooling off period. So now he's asking me, the visa bulletin says that F2A for India is current. On average, how long will it take for me to get my permanent residence? Well, see, the processing time and the visa waiting time are 2 different things. The processing time doesn't go away even though the visa wait time is current. So the processing time can be easily, I would say, anywhere from 6 to maybe even 18 months, because they're going to set you up for a local interview. All of these formalities can take time. Does the filing have to be done from Texas Service Center? I have no clue. Just look at the instructions. I don't keep track of that level of detail because other people in our office who do the logistics of the filings take care of those things. Estimated processing time of 5 to 7 months. What are my chances? Again, none of these calculations I can really vouch for, because you're trying to do some fine tuning which is completely beyond your control. You have heard that somewhere in one of my earlier recordings that it only takes 6 months. Yeah, that's a recording from 2015. I'm looking at that recording. It says Jan 8th, 2015 recording. So 3 years, everything has changed. Does the processing time of processing centers vary highly from monthly? Yeah, it can vary. Processing time usually doesn't fluctuate very rapidly, but it can. Also, the visa dates can fluctuate. You can file the I-485 as soon as the I-130 is filed. You can file them concurrently if the dates are current. I read somewhere, if the beneficiary receives the adjustment of status or consular processing approval before the 2-year anniversary of their marriage, they will receive conditional green card. That is correct. It will be valid for 2 years. Can you explain the CPR in detail? No, not really, but I can give it to you briefly. Okay. So if your green card gets approved, adjustment of status gets approved 2 years after you were married, you will get the permanent green card. Otherwise, you'll get a conditional green card, which would require you to remove the condition by showing the government either that you are still married or that even though you are separated or divorced, marriage was entered into good faith. That's generically what conditional permanent residence is. So even if the marriage breaks apart, after the conditional permanent residence is approved, you should still be able to get your green card if you can prove that the marriage was an honest marriage. How long will it take for a PR to convert to citizenship? So if you are married to a green card holder, 5 years. If you are married to a US citizen, 3 years. And by the way, the 3 years or the 5 years doesn't begin from removal of the condition. It begins from the date of conditional permanent residence approval. Okay. There are 2 tables in the visa bulletin. What is the difference? Well, there are the dates for filing and final action dates. Final action dates, as I recall, are the same as whatever is mentioned in the visa bulletin. But sometimes when people are in the United States, they might be able to file their 485 earlier. And you should look at the USCIS webpage for every month to see if there are any earlier filings possible. Those are called dates for filing. Okay. *5 if you have a follow-up question. Press *5 if you have a follow-up question. Press *5 on your phone if you have a follow-up question. Because I just saw somebody from India log in. Okay. We'll keep going. Next frequently asked question is from Kaushik. Working for employer A, H1B is expiring December 31st. Applied extension in July. RFE was issued to provide client letter, etc. So we did withdraw the extension, and the client and the prime vendor relationship also ending this year. My client manager asked me to come up. So basically what is going on is he's got several options. All these are happening at the same time. Prime vendor is applying, actually I already discussed this before, but I'll do it again. Prime vendor is applying transfer. Current employer is applying extension. Employer B is applying transfer. Can we apply 2 transfers while the extension is in process? Absolutely. With different clients? Sure. If the extension is denied, will the other 2 transfers will be denied? No. But you might have to go outside USA for visa stamping. So the denial of one extension does not affect the merits of the 2 transfers. But because you will be out of status, it would probably require you to go outside USA. It's okay to accept all 3 and take whichever one you want. I mentioned this before earlier in answering the first question, but I'll repeat it to keep each question complete. You can have a transfer, another transfer, an extension, an amendment, all of them pending, no problem. Approval of one does not overrule another pending application, nor does it overrule another approval. So you'll be able to take any one of these under immigration law, but make sure you don't have any exposure under contract law, that you've not signed any contracts, etc., to stay with one employer or the other. Okay, this is fine otherwise. *5 if you have a follow-up question. *5. Okay. The next frequently asked question is, my I-140, this is from YAS73, my I-140 is approved under EB1C, 485 has been applied, but 180 days are not over. Is it safe to change employers? If you had asked me 3 months ago, I would have said yes, because the law only requires that by the time the government questions you, 180 days should have passed. It does not require you to stay with the same employer. But recently, just a few months ago, a client in Minnesota had this weird problem where the government denied his 485 because he left the first employer before 180 days were over. I think that's a dumb denial, and a lawsuit is being filed. I think the government is going to lose. But to keep things simple, might as well just wait 180 days if you have a choice. Okay. *5 if you have a follow-up question. *5. All right. So let's begin with, I think we have frequently asked questions are done. Let's start doing our non-frequently asked questions. First one is from Ishant85. I-140 is approved for over 6 months. If I change my job within the same job code, do I have to go through the entire I-140 again? You have to go through the PERM again. You'll carry your priority date, and you'll carry your right to extend an H-1B through any employer because of the old I-140 approval. But you have to start the PERM and the I-140 all over again. Okay. *5 if you have a follow-up question. *5. All right. Next question is about what reason should I give for withdrawal of my N400? Are you on the phone? Press *5 if you are. Okay. You should consult a lawyer. This is not something I can respond without knowing a lot more about your background. So either set up a consultation in our office or talk with a lawyer locally where you are, which is what I would recommend in case you need to go to the USCIS and talk with somebody local. So you can do that, but this needs a specific consultation with an understanding of what your background is. Okay. Next question. I'm Canadian, US 1, 2, 3, 4, 5, 6. I'm Canadian moving to US on TN. Boyfriend is Portuguese. I would like him to move with me. You don't really have a lot of options. Unless you're a common law partner and the state you're moving to accepts the common law marriage, you will not be able to get any kind of visa. What happens is, in cases where somebody is not entitled to a derivative visa like a TD visa, which is the derivative for TN, they are able to get like a B2 visa. One example is if I come to USA on H1, but my mother is alone and in India, she's not entitled to an H4, but I can bring her on a B2 and I can keep extending that. By the same token, a common law partner, if not accepted as a spouse but is accepted as a common law partner in the US state where you are coming, might be entitled to the same benefits. Otherwise, without marriage, your boyfriend doesn't get anything through you. *5 if you have a follow-up question. *5. Next question, somebody wants to file an I-130. So is there any relationship between being present in the US and submitting I-130? And the answer is no. You could file from India or wherever you are. But here is the problem. Along with the I-130 and along with some of these applications, somewhere along the line, you have to file your affidavit of support. Affidavit of support can only be filed by US green card holders and US citizens who are domiciled in USA. So what we have done is, when, let's say that a husband and wife, they got married, let's say the husband is a citizen, doesn't matter, green card holder, same law applies, except that you have to protect your own green card. Citizenship, no one cares how long you stay outside USA. So in our case, one of the cases, husband was living in London, wife was working for one of the multinational organizations. She was working, I forgot where, but it was somewhere in Europe, not England. So they filed the I-130. Husband is a US citizen. They filed the I-130, but just before going for the interview, where the 864, the affidavit of support, would be questioned, we were able to show that the husband was actively in the process of moving back to USA, which means he had applied for jobs, they had rented an apartment, so therefore he was getting to be domiciled in USA, and that was sufficient. So just keep that in mind. *5 if you have a follow-up question. So to sum up, applying for the I-130 doesn't require you to be in USA, but the affidavit of support at some point would require you to be actively seeking to be domiciled back in USA. Next question is, let's see, Jordan. I have 2 questions. Filing citizenship for my parents. My parents came to the United States in 2016 on green card and stayed out of USA for 6 months. When should I file for their citizenship? Well, I think, Jordan, you should have a consultation. Again, I would prefer that you do it with a local lawyer where your parents live, just in case they want the lawyer to file the naturalization for them and go to the interview with them. Talk with them, but 6 months or over can become a problem because there has to be an explanation. If it is even 1 day less than 6 months, it is no problem. Because the calculation for naturalization is, in the last 5 years immediately prior to the naturalization application, you must have lived in the USA 2.5 years. You don't have to be in USA all 5 years. But none of your stay outside USA should be 6 months or more. Just keep that in mind, because they're going to ask you for an explanation. You are married and above 21. Can they file for my green card as a green card holder? Let me think about this. I don't remember if you, I think you, yeah, that's right. They can only file for a single person. For a married, an immigrant cannot apply it for a married child, married son or daughter, not child, adult son or daughter. So they cannot apply for you. Okay. Star 5, if you have a follow-up question on this, press star 5. All right, let's go on to the next question. SK 1990, I have a valid visa stamp on my passport till December 2020. My husband then switched the employer. I-5 13 years progress, last 6 months. Can I travel to India and come back with old visa stamp? Yes, you can. But should you? I have a valid visa stamp, I believe, so H4 visa stamp. Yeah, I don't see any problem with that. You should be able to come back. I don't see any problem with that. Star 5, if you have a follow-up question, star 5. Okay. Then the next question is executive transfer. I'm on an L1A visa, 1.5 years, with a US affiliate, company B of foreign parent company, company A. Job is now being transferred to another fully owned US entity, company C. Is there an option to continue employment with new company C on the same L1A? I don't remember the details. I really don't. I want to say that an amendment may not be required, but I don't want to commit to that. So you can either look at the regulations. They're pretty clear, actually. You can go to the USCIS website, look at the regulations, and they are 8 CFR. I'm trying to remember, is it 214.B? I think it's 214.2. So 8 CFR 214.2, look at subsection L. L is for L1. So there it will tell you when an amendment is required. I think if you move within the same group of companies, it should not be required, but I don't remember for sure. Okay. As I have I-485 pending 180 days, EAD and AP is already received. Is use of job porting? It's always a reasonable option. Yes, absolutely. Absolutely. I don't see any problem with that either. You can use portability for sure. Okay. Star 5, if you have a follow-up question on this. Star 5. All right. Next question is, Van Mal, my EAD was due for renewal and we submitted all documents in January, which is much in advance. Okay. EAD expires in March. Auto renewal for 180 days. I continued working. Still awaiting answer. I'm waiting and I'm currently on L2 status. Should they be compensating while I'm on my leave? No. The company does not have to compensate you when you are on leave. Can my company go ahead and find a replacement for me? Can they? Yes, of course. All employments are at will usually unless there is a contract. So that's a question to be addressed by a local lawyer who does employment-based practice. But there's nothing stopping the company. They're not married to you. Does going to USCIS office personally help? Nope. It has been 11 months since our first submission. Could our international travel have played a part in this? I don't know. I can't guess what happened. But if things are getting delayed, talk to a local lawyer to file a lawsuit against the government. That might work. If they can't do it, contact us. We'll do our best to help you. We'll file a lawsuit for you, see how it works out. Okay. It seems like government is only moving when people are filing lawsuits now. Very unfortunate. You can also try contacting your local congressman's office and see if they can help you in this. Okay. I'm talking about US congressman, not state. Okay. Star 5, if you have a follow-up question on this. Star 5. Okay. Next question is from Saranya, who says, I've completed 16 credits of Masters in Electrical and Computer Engineering, Embedded Software major. In H4, okay. I'm also working in automotive full-time for top employer. on H4 EAD. My bachelor's is in electronics and instrumentation. And I still work for electronics domain as an embedded software engineer. Okay. Previous experience in India, I got a long RFB for H1B. My employer didn't give me RFE package. Manager sent the reasons. It's too complex. They are withdrawing the H1B. Okay. I don't think that was a good idea. They should be fighting it. Because basically, what is an embedded software engineer? Embedded software is simply another form of software which, instead of directly going into the computer's hard drive, is going into firmware or hardware. Yeah, that's what an embedded software is. So I don't know why they would withdraw the case. Anyhow, my husband has I-140 approved, but I haven't been added as a beneficiary. That's okay. I wish to convert to F1 as H4 EAD is not certain. I will do a change of status to F1 if I have to go India before or after in my OPT period. Will the I-140 approval affect my chances of F1 visa? This is so difficult to predict, Saranya. Anybody who has an intention to stay in the USA long term can have an F1 denial. So I do not know the answer to that question. Your husband is in USA. That alone, without any application pending on your behalf or your husband's, can be a ground for denial. So F1 visas are very delicate. They can be denied for a million reasons. H4s are not. H4s are solid visas. Star 5 if you have a follow-up question on this. Star 5. Okay. Next question is BW184, etc. I have a 485 pending. Based on that, I have applied for my EAD extension. This is going to be my third extension. USCIS has mailed me a receipt notice, but I didn't receive it. Is there a way I can access the receipt notice online? I don't think there is a way. You can check the status, but I don't think you can get a receipt notice. Okay. So I do not know of any other way you can do this. You have to wait for the receipt. Star 5 if you have a follow-up question. Star 5. Okay, folks. This was very quick today. I was able to wrap this up in half the time I usually take. Do you have any questions? Anyone has any questions, new questions? Press star 5. Press star 5 if you have any questions. There's one so far. One question from Illinois. Another question from Pennsylvania. Okay. So there's two questions. All right. I won't take any more questions, folks. Raise your hand now if you have any other questions. All right. So two people. Let's open Pennsylvania first because they logged in first. So Pennsylvania. Oh, sorry. This is not Pennsylvania. I think I opened. No, I did open Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania, go ahead.
Hi, Rajiv. Good afternoon.
Good afternoon, sir.
I have one question. What is the waiting time right now for the H4 approval and H4 EADs?
I just discussed that question 10 minutes ago. I said we just filed a lawsuit last Thursday where an H4 and H4 EAD has been pending since last August, over 1 year. Okay. So I don't know if I can give you any time, but people are filing lawsuits constantly now. It appears that the government is just sitting on these cases. Okay.
Okay, but at least it will be like a 5 to 6 months waiting time, and if we are not getting to at that time, we can still ask the USCIS for the status.
You can ask for status, but that doesn't mean you're gonna get approval. You can ask for status. Okay.
Okay. At least maybe 4 to 5 months is a good waiting time, right?
I think you should look at the USCIS website, see what the average time they give is. After that, you can open a service request. Okay.
All right. Okay. Thank you, Rajiv.
Oh, you're welcome. Good luck, sir. Okay. Last question is from Illinois. Illinois, go ahead, please.
Hello, Rajesh, sir.
Hello, sir.
My name is Nisarg, and Thank you for answering my question.
Of course.
I received my I-45 birth certificate even though I submitted my birth certificate.
Okay.
So, my question is, what are the other supporting documents I should submit
Okay.
along with the birth
Hang
certificate?
on. Let me make a guess. You said you submitted a birth certificate, right?
Right.
Okay. The birth certificate was from
Correct.
municipal corporation?
Right. Okay.
But the birth was registered late, right?
Correct.
Yeah.
Right.
That's the normal thing they do. If you register your birth late, they will refuse to accept that. So what you do is, you first get a non-availability certificate from them that says there is no earlier record of this birth. Okay. First thing.
Okay.
Second thing you do is,
Okay.
you get 2 affidavits from people who know when you were born. It can be your mother and father, it can be your brothers and sisters, it can be your friends, anybody who, family friends. That's all. So that's easy enough.
Okay.
Okay.
Right.
That's all you need.
Oh, okay. Okay. And Rajesh sir, for this, can I Can I take consultation of yours for this matter?
Definitely. I mean, I don't know what else I can tell you. What I have told you free is what I would tell you even if I charged you money. So what you may want to do is, you can get the format of the affidavit. I'll send you the. Don't you have a lawyer, Nisarg?
Sorry?
You don't have a lawyer representing you?
No, not till this date. I consulted you before.
Oh, you did. Okay.
For the consultation.
Okay. If you need a sample affidavit, I can have one of our team members send you a sample affidavit.
Yeah, sure.
Okay. So just
I will contact you.
Yeah. You just send me an email. You have my email, help@immigration.com, and I'll have Heather send you a sample. Okay.
Okay.
Good luck.
Thank you.
You're welcome. Good luck.
Yeah.
All right. Well, folks, I think we are done early today. That's wonderful. As always, it is great to talk with all of you, and I look forward to talking again in 2 weeks. Take care, everyone. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.